Welcome. I'm Brendan Christian, director at Christian, the law firm, and in this clip we're focusing on private limited companies limited by shares, and more particularly the relevant forms, the company's house forms that need to be completed at certain key stages, i.e. when key developments occur within the life of the company. And I think the best way to do this is to do this by way of an example, as opposed to discussing these companies' house forms in the abstract. I'll talk through the forms in the course of an example. By way of a disclaimer, please note that the example, and particularly the facts underpinning the example, will all be governed by the law of England and Wales, i.e. the Companies Act 2006, as applied in England and Wales. Please note that disclaimer. Right, let's then begin with the actual example. 1 year ago, exactly 12 months ago to the day, 5 individuals, 5 natural persons came together and they decided, as entrepreneurs do, that they're going to incorporate and register a private limited company limited by shares and registered as such in England and Wales. They're going to incorporate a private limited company limited by shares. There's 5 of them. So they'll all be the 5 shareholders, and they'll start by way of share capital. They'll start with 100 shares, each individual owning 20 shares in this newly formed company. And at the same time, there'll also be the 5 directors of the company. For those who don't know, the Companies Act 2006 in England and Wales, you don't strictly need a company secretary anymore. It's not strictly necessary. And so they decide to dispense with that and forego with that. And so there'll just be the 5 shareholders, each holding 20 shares in this newly incorporated company. And there'll also be the 5 directors. At the date of incorporation of the company, they're issued with the certificate of incorporation, naturally, from Companies House, certifying that indeed and in fact a private limited company limited by shares now exists with the name that they gave the company, that they all agreed upon. So they have the certificate of incorporation. They also have the Articles of Association, which is effectively the company's constitution, and they've got the Memorandum of Association as well. And of course, they also have, each of them, a share certificate indicating that they each own 20 shares at the date of incorporation. And so they crack on. Off they go. They start trading via this private limited company, limited by shares. And as we know, the first year for a startup is invariably the most difficult year. And so it is a difficult year for this particular private limited company, limited by shares. As a result of which, the stress of it all becomes a bit too much for one of the individuals. They can't manage the risk and the stress. And so what they decide, the 5 of them, because they all started out right at the very beginning as good friends, and so they still have that effective bond. And so this is resolved amicably. Please know, in reality, out there we see it a lot. It could be very, very messy and very difficult trying to get rid of one shareholder or one director. And so if you're ever in a situation where it is particularly difficult and it is particularly stressful and messy, please do take specialist legal advice. Please definitely do take specialist legal advice, i.e. come and speak to us. But nonetheless, these were 5 good friends at the get-go, so it's resolved amicably. So what happens? How then is the question? How then do you effect these changes using the appropriate Companies House forms? Well, the first form you are going to need, in my view, is a TM01. TM01, and that's terminating the appointment as a director or of a director. So to get rid of this one individual as a director, in her capacity as director, what you need to do is, the rest of you, the remaining 4 of you, need to complete the TM01 and file that with Companies House. And that's how you would get rid of a director in a private limited company limited by shares. It's Form TM01. What then of the question of that individual's shares and her shareholding within the company? Because we've dispensed with her as a director now. So what of in her capacity as a shareholder? Well, the first thing I would suggest you do is draft up a shareholders agreement. And remember, this is all being done amicably. So it's fairly easy to do. Draft up a shareholders agreement in terms of which, and it will depend on the agreement reached between these five individuals. Let's just say, in this particular example, this outgoing shareholder decides to divide, by way of a sale of her shares, to divide the shares equally between the remaining 4 directors. And so because she had 20 at the date of incorporation, she decides, and bear with my very poor maths, she decides to pass 5 shares to each of the remaining shareholders at fair value, of course, at fair value. And so that's what the shareholders agreement will record in writing. And so each of the remaining 4 shareholders each gets 5 shares in terms of the shareholder agreement. Please note, depending on the value of these shares, stamp duty might be payable. Just watch that. But on this particular example, the company wasn't doing well in the past 12 months, and so the shares are really, really valued low. So low, actually, that they're below the threshold in terms of which stamp duty is not particularly payable. And so she passes 5 shares to shareholder A, 5 shares to shareholder B, 5 shares to shareholder C, and 5 shares to shareholder D. And so that's how you get rid of her shareholding within the company. The appropriate Companies House forms to record that, I would suggest you use form SH01. SH01, that's return of allotment of shares. It's just to bring Companies House up to speed in terms of what the allotment of share capital within the companies is at the date of that key event. So use form SH01. It's also a good idea to issue the remaining 4 shareholders with share certificates as well, just as proof that they own these additional 5 shares each, as it were. While we were on the subject, it was a small company, so let's just say at the date of incorporation, you all used this particular individual's address as the company's registered address in England and Wales. For some reason or another, you'll decide at the date of incorporation, that's what you do. How do you change? How do you change the company's registered address? That is form AD01. Change of registered address is form AD01. And so that's how you go about changing the company's registered address. And so really, those largely are the 4 key forms you would need to effect the changes that were discussed in this particular example. Of course, the other obvious point as well is that throughout the process, from the very get-go, have regard to the company's articles of association, because it will tell you what would need to happen internally within the company to record these key changes, these key developments within the company. It might be, for example, with respect to the individual being terminated as a director, it might be that some form of special meeting is required of the board at which a special resolution is adopted following a vote taken, for example, i.e. by way of unanimous decision or by way of majority decision. And so all of those minutes and all of those written records within the company would need to happen as well. So please do check throughout the process. Do stick and follow strictly and adhere to strictly the actual company's articles of association in all of this process as well. Thank you very, very much indeed. I am Brendan Christian, director at Christian, the law firm. And if you need any assistance on any particular matter that we've discussed, please do get in contact with us. Thank you.